Okay, thanks, Mimi. I was speaking alone, so no. Okay, no worry. So I'm Vincent. I'm the director of the Chapter 54 program, which is a program operated by Partech. Partech being the main investor into the African tech space, with investments into successful companies like Wave, Trade Depot, TerraPay, Naui, and so on and so on. So Chapter 54 is a side business of Partech. We define ourselves as a Europe to Africa accelerator, which means that every year we work with about 10 European tech companies and we provide them with all the support they may need to initiate business, revenues, operations in Africa. We have worked with big names such as SumUp, Ledger, eBury, OVH Cloud, but we are also able to work with much smaller organizations. So because our day-to-day business is to help European companies expanding in Africa, this question of how you structure your business locally in terms of incorporation or not, do I have to open a subsidiary or not, what are the pros and cons of different models? So every day we answer these questions and every day we do the same answer. It depends, which is not a very interesting answer. So that's why we decided to dedicate a webinar specifically to this topic of incorporating and of more generally, how do I structure, legally speaking, my business in Africa? But it's better to have experts to address this topic. So that's why I have the pleasure to let the mic to Laurence of the Lem&Co law firm. And Laurence, the floor is yours.
Thank you, Vincent, for this introduction. So hi, everyone. So I'm Laurence Elong Mbassi. I'm the founder of Lem&Co. So Lem&Co is a law firm based in Paris and Accra. Actually, we started in Accra as a team and then expanded to Paris. We advise companies, private equity funds on their operations, project investments in West and Central Africa. So Ghana, Francophone countries, and also a few assignments in Morocco. At Lem&Co, we build bridges within Africa and between Africa and the rest of the world. So with our core team, obviously, but also with the support of our network of partners who are based in different jurisdictions in Africa or outside of Africa. So before digging further into this webinar, I just want to make a very quick disclaimer, which is that we are going to discuss here legal topics, but also tax topics, because we see that often legal is handled by legal teams, tax by finance team or tax teams for bigger organizations. And at our firm, we really want to address those two topics together because it's really key in the way of addressing issues on the African continent. But I'll try not to be too boring when talking about tax. At least, yeah, that's a promise I'm making. I'll try. So we'll start with discussing different approaches. I think the reason why, as Vincent was explaining, we wanted to do this webinar is because often the question that arises is, how do I structure my expansion in Africa? And in the tech sector, we see that many companies have launched playbook because it's easier to deploy that way. And these launch playbooks usually help them reduce the time to market. But we also see that if it works in some instances, in other cases, it may not always be the right approach to replicate a model that has worked in the market in other markets. And so that's why here we are going to discuss different approaches, explain what can be the downsides or maybe the key takeaways of each of those models, and make sure that we give you the tips and what to think about before considering one structure or another, because again, and Vincent said it, it really depends, and there are some legal and tax considerations that have to be understood and factored before taking a decision. And the tax is very important because it has an impact on your money, and I think this is something that most of you understand very well. I mean, we start with discussing the setting up via a subsidiary. Everybody knows what a subsidiary is, but I think what is important to mention here is that if everybody knows it's a legal entity, in most cases, we see foreign companies looking at limited liability structures because obviously it will limit the liability of the shareholders regarding the debt of the local entity to their contributions. Mainly, we are talking about the stated capital. But I think it's also important to mention that when you consider expanding into a market and your business entails having interactions with the government or with companies in the private sector, which prefers that you have a local presence, a strong local presence, it's true that the subsidiary approach is to be considered. One of the aspects that is also important is that as a legal entity, a subsidiary can benefit from the provisions of a double tax agreement if, of course, there is one in force between the company of the parent company and the host country. So this is also something that can be taken into consideration, even if tax should not be the main or the key driver of an investment decision. So in the different approaches that we'll discuss, you'll always see on the left this column with the key requirements for you to see what generally is required in the host country, in most of the countries that we operate in. So you see that when you have a subsidiary, obviously you need to register with the local registry, open a bank account, etc. And so when you look at the level of the local requirements that you have, it makes sense to do that if you come for a long-term period and not just for like a one-shot project. Now, in terms of practical aspects, very quickly, be careful about minimum capital requirements, because we see that in some markets like Ghana, when companies have been expanding to, let's say, Côte d'Ivoire and Burkina Faso or Senegal, they come to a country like Ghana with the same mindset, and they realize that you have some stated capital requirements which are quite significant, because if you want in Ghana to wholly own the subsidiary that you set up as a foreign investor, you need to transfer to the country 500,000 USD, and those USD will be converted into Ghana cedis. So you also have a foreign exchange risk here that it has to be, of course, taken into consideration. So this is something that sometimes we may not think about, but it's worth mentioning. Also, when you talk about having a subsidiary, you have, of course, the question of how you repatriate cash. So I won't extend too much on that now because it's going to be discussed later, but dividend taxation is also something that has some implications, and this is something that has to be taken into consideration. In Ghana, the rate is quite low, but in other markets, it can be much higher. So, so to be factored as well. And then transfer pricing rules, that's something that some of you may have heard of. Basically, these are rules which aims at preventing indirect transfer of benefits by playing between different taxation rates. I promise not to be boring, so I won't develop too much on that, but if you have questions, don't hesitate. But when you have a subsidiary or even a branch, actually, these are rules that when you expand, you have to take into consideration for your intra-group transaction flows, because then you'll have to make them consistent group-wide. So I mentioned the branch. This is another way of approaching your expansion in Africa and in any markets, actually. So the branch is an entity that needs to be registered with the local registry. But the thing is that it has a legal personality that is the same as that of the parent company, but it has a tax personality that is distinct from the parent company. And that's very important because when you have a branch in a given market, then that branch will be subject to corporate income tax and as if it was an incorporated legal entity with a legal personality. So it's a distinction that is important to have in mind. In some markets, we put as an advantage that you can have lower registration costs, but it's not always the case. So it's something also that sometimes you may have the same costs to incorporate a branch or a subsidiary, but it's true that in many markets, it can go faster to incorporate a branch. So depending on what are your operational constraints, also the duration of the contract that you have, if you are planning to set up just for a project which is very short, you may not want, as I said earlier, to incorporate a subsidiary. But because there's a but, in practice, we see that in Francophone countries, for example, some companies expand by incorporating a branch, but then they realize that they want to stay longer. And because when you incorporate a branch as a foreign company in a country, for example, like Côte d'Ivoire, which is part of the OHADA organization, very quickly, OHADA is an organization which aims at harmonizing corporate law across several countries, and Côte d'Ivoire is part of that organization. But when you incorporate a branch, you set up a branch in that country as a company which is not part of OHADA, so for example, a French company, then your branch has a limited duration of life. And then if you have a branch for 4 years, that's fine. But if you want to have a branch, you cannot have a branch for more than 4 years. So basically, you need to contribute that business at some point to a legal entity, so to a subsidiary. So it's also something to bear in mind, because if you come for long term, you'd better incorporate a subsidiary. Also, I mentioned that in some markets where you have minimum stated capital requirement, some players try to incorporate a branch to avoid that. And in Ghana, for example, they have decided that even as a branch, you need to have a minimum stated capital requirement or contribution, which doesn't really make sense from a legal perspective, but it was made that way to prevent this shopping between subsidiary and branch due to capital requirements. So I think the last point to mention here is that as a branch, because the entity doesn't have a legal personality, then the entity may not be able to benefit from the provisions of a double tax agreement if there is one. So it's also something to consider. Now, you have here a table comparing subsidiary and branch. And I think the main takeaway here is the branch profit tax. I promise I won't be boring, so I'll try to explain that. When you have a subsidiary and you want to repatriate cash, you make a dividend distribution. And a dividend distribution is something that has legal implications. You need the General Assembly, and that General Assembly will decide the amount of dividend paid. And then if you have in the host country legislation providing for a withholding tax applicable to dividend, that withholding tax, you see 10%, for example, in Nigeria, will apply to the amount of dividend that is being transferred, subject to double tax agreement if there are some in force, which may reduce the level of that withholding tax. When you are in a situation of a branch, because it's the same legal entity, some countries implement what is called a branch profit tax. So when you have your branch will be subject to, the revenue will be subject to corporate income tax. And then the profit after tax will be subject to that branch profit tax, because it will be deemed that the profit after tax is automatically distributed to the mother company. So which means that when you have a branch, your profit after tax is deemed distributed, even if you don't make any transfer of cash. So it's something that you have to know before setting up a branch, because basically it can affect your business plan if you haven't anticipated it. In some cases, you can have, if you have a DTA that neutralizes that branch profit tax, it can apply. It can apply. Why? Because even if the branch doesn't have a legal personality, because it's a transfer to the profit of the parent company, then it's the legal entity abroad that will benefit from the DTA provisions. DTA standing for double tax agreement. So I won't be too long on that, but if you have some questions, I'm happy to address. But just to know that when you have a branch, think about a branch profit tax, because it can really affect your margin, typically, if it hasn't been anticipated. So joint ventures, it's another. I think it's a way of expanding that many of you have heard about. You can enter into joint ventures, either incorporated. We see that when you partner with a local company, either you invest or you create a new company that is going to basically materialize the partnership. But it can also be an incorporated joint venture, simply by entering into an agreement, a partnership agreement. And so we often see both situations and with different implications. Again, in this case, if obviously if it's an incorporated entity, you'll have the same requirement as if you have a subsidiary, because it's a legal entity. I think here I want to mention that in practice, when we see issues in joint venture projects, or when you look at it maybe from the first layer, we see a lot of corporate governance issues between the shareholders, etc. But when you dig further, we often see that the issues that we have to address with our clients often have to do with a misalignment between the parties. And so we realize that in many cases, the issues with joint ventures come from a kind of misalignment on the contributions of each of the parties. So when approaching a new market, we see that many companies think we need to do a joint venture, but it's not something that should be taken from that angle. We see that when there is often when there is a success, is because the joint venture is kind of a consequence of a meeting between the foreign company and a local partner, and either the agreement or the entity just comes to materialize that alignment between the parties. And this is where you see that you can really bring or draw a lot of value of that partnership. So as lawyers, we are here to basically make sure that the agreements materialize what you want to achieve. But it's very important that from the beginning, the joint venture is not entered into because it is supposed to be the right approach, but it has to be really the approach that makes the most sense in a specific context and in that specific country as well. Because it's true that for local content requirements in some markets, we see that some companies are obliged to partner. But if you have the local partner, but you don't have that alignment of values and the rules of each party is not clearly set, you may face a lot of issues. Now, in terms of tax, I won't develop too much here, because if it's an incorporated joint venture, then you will have the same implication as for a normal entity. And if it's a contract, I'll discuss that later. it's you can have some implications that I will develop. So again, don't hesitate at the end if you have some questions to put them in the chat because yeah, we'll address that at the end. The representation office is the next topic that I want to discuss, and which is a very interesting one because when you are planning to make prospection in a market without necessarily incorporating an entity, it completely makes sense. Oh, sorry. It completely makes sense, and it's okay. Sorry, okay. And setting up a rep office is actually very easy. You don't need to, as you see on the left, you don't really need to have high requirements, but the rep office needs to be registered with a local registry. But it's a way of minimizing your cost because you can enter this market, I mean, any market by doing prospection, but you shouldn't do revenue generating activity. And that's a very important topic because the generating revenue activity is what will put you out of the rep office scope. So when you are a rep office, you are supposed to do activities that are not in the scope of your core business. So for example, you can do prospection, you can do research, you can do promotion, but typically if you do, you can even do publicity, but if you do publicity, but publicity is your core business, then you have an issue. And what is at stake here is that when you are a rep office, usually you are subject to a simplified tax regime. And typically in Côte d'Ivoire, for example, it means that you just pay the minimum tax. You may hire a team there, so you also pay a tax on salaries and the taxes that are due on, for example, the salary that you pay to your employees. But because you are not supposed to generate any activity, you will not be subject to corporate income tax. Now, in practice, what we see is that in some cases, the role of the rep office may go beyond what was supposed to be. And this is where you can have some permanent establishment issues, which trigger corporate taxation in the country. So in the same intent, not to be too boring, I'm going to explain very quickly what permanent establishment is. It's a tax concept which is meant to address a very simple situation. The situation being that you are a foreign investor, you want to expand in the market, and you decide that, well, you don't need to incorporate in that market because you are not, I mean, it's not the way you want to operate. And you feel that you are going to do prospection, it's not going to generate revenue, so you don't see the point of incorporating. But then when you set up your entity, when you deploy, what happens is that your operations in the country are not interpreted the same way by the local tax authorities. And they will consider that, well, even if you think that you don't have revenue generating activities, well, we consider that you do because you are operating this way or this way. And this is where the permanent establishment concept comes in, because it's a way of saying, well, that activity was not incorporated, but is generating revenue, so it will be subject to tax. And in the specific case of the rep office, it's very important to make sure that the way you want to operate is actually consistent also with the interpretation that the local authorities have of your operation. I'm going to give you a very simple example. You set up a rep office, which objective is to find clients, just find clients, and then the clients are signed by the parent company. In this case, you can have, if you set up, for example, in, I don't know, just randomly, Côte d'Ivoire, Cote d'Ivoire will say, well, if your team goes doing prospection and enter into contact with some potential clients, even if they don't sign with those clients, well, if there is a contact with the client, it's still an ancillary or it's a preparatory activity. So it's not considered as a revenue generating activity. So it's fine, you have a rep office. But in another market, the same rep office with a team entering into contact with potential clients can be considered as a revenue generating activity, because in some markets, the tax authorities will consider that, well, when you have a rep office and the rep office get in touch with the client, getting in touch with the client is very close from the signing with the client. And the signing with the client is actually considered as a revenue generating activity. So, well, in this case, we'll consider that you have generated profit in the country. So this is where, depending on the market, again, the rep office is a very good, can be a very good approach to minimize costs. But depending on how it is implemented and how it's also being, addressed in each market, you have different implications. So again, this is something that we can discuss further. But I thought it would be useful to discuss here. So in this case, we'll discuss franchise and management lease. So for these two topics, we are talking again about from the foreign investor perspective, non-incorporated schemes, because when you are a foreign investor and you go to you want to deploy in different markets, franchise, to start with that, can be a good approach if you have a strong brand. Also, if you have, if you are looking at some markets where you have the good level of IP rights, intellectual property rights protection, because in some mature market like South Africa, we see a lot of franchise agreements. But in other markets, even if you have some examples, I'm thinking about Burger King that is mentioned here. Burger King is present in Ghana. But you see a country like Ghana has an IP legal system that would be less developed than South Africa, even if they are improving. I mentioned here that when you want to register a brand, it can take a lot of months. So it doesn't prevent this kind of scheme, but it's really something to consider before deploying a franchise agreement, where you'll have basically your franchisee who will develop the business, and you as a foreign company, you will just provide some specifications, and maybe you can also license your brand. And it's a way of expanding with lower capital requirements for you, and at least rely on the market knowledge of your franchisee. But yeah, I think what I can mention here is that in Francophone countries, you have an organization which allows you to register a brand in several countries, in several Francophone countries. But there are a few things to be careful about, like prior art search. Prior art search is when you want to register your brand, but you need to check that, for example, no other entity, no other brand has been registered with the same name. And we know that, for example, in Francophone countries, if you don't request it specifically, you can actually end up registering a brand, not knowing that there is another brand with the same name, which has been registered. So I want to talk more about the example of Paul, because Paul is a typical example of a brand that is French, and that has use the franchise model to revamp its brand in Africa. So I hope there's nobody from Paul in the webinar, but in France, Paul is not really the. It's now it's a brand now that you find in train stations. At the beginning, it used to be quite trendy, but nowadays you will find Paul in France mainly in train stations. At least this is where I see it. Whereas in Africa, Paul is quite has a very different image. Whether you go to Gabon or to Côte d'Ivoire, you see people can do business meetings at Paul. Even in Morocco, in Morocco, Paul is quite well seen. And it has a different image from the image it has in France. At least that's what I see. So to me, Paul is a very good example of a brand that has deployed in African markets and has actually maintained or even improved its brand by deploying in African markets. So I think I'll leave it there for the franchise model. Now, the management lease concept, it's what is known in French as location-gérance. It's a French concept that allows basically an asset owner to lease the business to a manager who has a specific expertise. For an investor, it's a good way to test the waters as well. For example, you are in the hotel industry, you want to deploy in a specific market, but you don't want to do it from scratch. So you take that management role of a business to see how it goes. So it's not, I haven't seen that a lot in Francophone countries in several sectors, but we see it in the touristic industry. That's my experience. But what we see also is that in these kind of schemes, you have to be careful about the business registration. So it's a model that can be really successful in the hotel, or if you have a touristic business, it works well. But the due diligence on the business is key, because we can see that sometimes we have some surprises on what is behind the business that you take as a lease. So the next topic I want to discuss is the agent agreements. The agent is very interesting because it's a very common way of thinking about deploying in a new market. So I haven't seen that model so much in the tech industry, more in I would say in some in other sectors, sometimes industrial sectors, very specific sectors, or FMCG as well. But the thing is that with the agent model, you basically appoint someone in the host country to have a presence. That presence can be very limited. You appoint someone who will basically allow you to have sales in that market, and the person is paid by a commission. It's a scheme that is not to be confused with a reseller model, because you don't have like in a distribution model or transfer of ownership of the goods to the agent. But it's a model that comes with sometimes with some tax, I would say tax issues. because you can have, in some instances, a situation where, depending on the role of the agent and depending on whether he has the possibility to enter into contracts that can bind the foreign company, then it can be considered that the company is actually generating revenue locally, because the objective of deploying an agent model is that the agent will allow you to have local sales, but then you will contract from the parent company and not locally. So you have someone who allows you to make sales, gets a commission, and the sales is concluded directly by the parent company. So if, because of the way you have set up the agent model, you start generating taxable revenue in the country, then the model is completely different. So regarding the way you want to set up, sometimes you may have that option between, okay, do I appoint someone who will be representing me in the country, or should I just be in an approach where I'm just concluding a contract directly from where I am without anybody on site? So that's typically the case in the service agreement. It's also another approach, and I think all of you know what a service agreement is. But again, depending on how it is structured, if you are in a scheme where you don't incorporate an entity locally, you don't have any entry cost, but you have to structure your agreements the right way. For service agreement, we'll have the same issue of well structuring it. Maybe I'll give you just one example of situation that we often see is that, for example, you are a service provider, but as part of your service, you also procure some goods. And usually actually is the other way around. You are selling a product and then you have some ancillary services coming with the product. But if, let's say, your pricing in the contract is not broken down between service and goods, you may end up with adverse tax implications, because sometimes, and more likely than not, you'll have withholding tax applying in the host country to the service component of your contract. So if you don't break down the price, then you end up having the withholding tax applying to both service and goods, the sale of the goods. Whereas if you break it down, it shouldn't be the case. So this example is just to show that structuring well your service agreement is also something very important. Now I'll speed up a little bit so that because we have 1 hour, so that you can ask questions. I end up with some cash repatriation hurdles that we see in many cases, because cash, again, repatriation has an impact on your money. So to be very short, when you set up like a subsidiary in a market, think about whether you have some regulatory filings to be made, because we often see in Ghana, Cote d'Ivoire, that it's often overlooked. The typical case is the shareholders agreement. You realize that when you put in place a shareholders agreement with your subsidiary in a country like Cote d'Ivoire, you need to make some regulatory filings with the central bank representative so that you can repatriate the principal and the interest. You also need to register your shareholders loan with the tax authorities. And if you don't do that, you cannot repatriate the cash. And if you do it afterwards, when it's time to repatriate, then you incur penalties, etc. So this is typically the kind of situation where you see your margin reduced because you end up paying things that you could have avoided. In a country like Ghana, we see that some companies try to avoid registering with the Ghana Investment Promotion Center, and it's a requirement to be able to repatriate dividends. So I mentioned tax, I mentioned like some legal things to think about, but the regulatory aspect is also very important. So I mentioned it here. If you want the slides, we'll be able to send that to you because I'm going to accelerate. And what I want to also mention when it comes to cash repatriation is the fact that in some markets like Ghana and Nigeria, for some service agreements that you enter into with your subsidiaries, depending on the agreements that on the services like management fees, management services or technical assistance, which is very common, sometimes you need to register the agreement with a specific authority and you need to be approved before making the transfers. So we often see some issues there. And we also see some surprises in West Africa on the funds coming back to Europe because you have some transfer taxes applying on funds going out of the West African or the Central Bank or the Central Africa zone, and this can also affect margins. So to make a long story short, cash repatriation is not something that is automatic. I think everybody will agree that repatriating cash from Africa is a big issue, but there are ways to mitigate the timing and to minimize the cost and to avoid penalties, etc. So that's all for me. So if you have any questions, I'm very happy to address them.
And if you want to repatriate your funds, you can think of eBury, which is a UK fintech accelerated by Chapter 54. So they have solutions for you on most of the corridors between Africa and Europe and Africa. If you have any questions, let us know. Maybe I have one for you, Laurence. You have explained very well the different setups that may exist. But if we, for example, we consider the difference between the B2B and the B2G companies, for which categories of companies it is the most important, the most urgent to have a local presence?
Definitely the B2G. Because if you work with the government, it's very important to have a local presence. And usually it will be important to have a local presence and to have, because of local content requirements, to have a JV. That's what we see in practice.
Okay.
When I mean a JV, I mean a JV with the national of the country where you are expanding. Yeah.
Okay, thanks, Laurence. Any question in the room? Okay, so that's perfect. Laurence, you have been super clear. I think that it is the very first layer of knowledge we should all have regarding incorporations and the other models that may exist to expand in Africa. So thanks a lot, Laurence. If you want to have a presentation, the presentation, feel free to email me or me or Laurence. If you have questions on Chapter 54, on the services offered by Lem&Co, do not hesitate. And if you have ideas of other seminars, webinars we could organize, let us know too. For the ones who are not registered yet to the Chapter 54 newsletter, do it. For the people who are interested in what we do at Chapter 54, follow us on LinkedIn and Twitter. We communicate a lot on what we do and more importantly on what the companies accelerated by Chapter 54 do. And I'm going to leave you here and wish you a very good afternoon. Bye-bye.
Thank you. Good afternoon to everyone. Bye-bye.